Thank you so much for joining us. We'll go ahead and get started now. Good morning. Welcome to day 2 of the 2021 Path for Hope Virtual Summit. We appreciate you joining us. And on behalf of the Florida Department of Health in Volusia County, we're glad you're here. This session is being recorded, as are all sessions throughout the summit. My name is Lynn Kennedy, and I will be your facilitator for this session. You have joined the session entitled The Origin and Application of the Marchman Act. Just wanted to make sure you're all in the right space. All participants are muted during this session, and you can submit questions throughout in the chat, and there will be time for question and answer at the end of the presentation. We'd really like to thank our community, our Path for Hope Summit community partners that were on the planning committee: Advent Health, Community Coalition Alliance, One Voice for Volusia, SMA Healthcare, and the Volusia Recovery Alliance. It's my pleasure today to introduce you to Salvatore Gintoli, and I'll be happy to tell you a little bit about Mr. Gintoli. He has an MA in clinical psychology and over 20 years of clinical and operational leadership in behavioral health care. Mr. Gintoli's skills include leadership, crisis intervention, EBP training, public speaking, team building, and regulatory compliance. He has worked with SMA Healthcare for over 9 years as the Director of Operations, Facility Administrator, and most recently, the Senior Director of Crisis Services. As such, he is responsible for providing leadership, direction, and administrative oversight of SMA's crisis services in Volusia County, located at the Chet Bell Crisis Center. Mr. Gintoli represents SMA through collaboration and community partners, discourse with media outlets, and facilitation of trainings. He also works to develop the performance measures for the crisis division and to maintain compliance with regulations. Finally, Mr. Gintoli collaborates with regulatory oversight agencies such as ACA and DCF, with law enforcement and local area hospitals and behavioral health providers via his leadership at the monthly Volusia Flagler Central Receiving System Interagency Meeting. He is a seasoned certified mental health first aid instructor, both for the standard adult module and the public safety module, as well as crisis intervention training presenter and a member of the Volusia County Public Safety CISM team. Welcome, Tori.
Thank you so much, Lynn. It's really good to be here this morning. I get a lot of questions about the Marchman Act, 3, 4, 5 a week. It's not a very well understood regulation, and a lot of people are confused by how it works, and therefore it's not used as often as it could be. So I'm very thankful to have an opportunity this morning to talk about it. So let's talk about both the origin and the application of the Marchman Act today. So way back in the 70s, we had 2 separate acts here in Florida. We had the Myers Act and the Madden Act. The Myers Act was put in place to remove the stigma that surrounded alcoholism. The Madden Act addressed the rehabilitation of quote unquote drug dependence. Now, the problem is that neither of these acts really did anything to instruct providers of services on how to operate. So by the 90s, we had a really big push to clarify how substance use services should be administered. And that led to the repeal of both the Myers and the Madden Acts. They were replaced with the Marchman Act in 1993. This is a photo of the Reverend Hal Marchman. That's him at the Speedway. As you can see, it looked very different back then. He was a Baptist preacher, and he was in recovery. And he wasn't just a guy who was satisfied with standing behind the pulpit. He was out in the streets of Daytona Beach and the surrounding areas, helping people with their recovery. And he was the primary person who lobbied our legislature to improve the licensing and monitoring of treatment facilities. So this next slide here, this is the actual criteria for the Marchman Act. I'm going to go ahead and read it off. I have to take a big, deep breath first. It's pretty wordy. There's not a lot of punctuation other than commas. So this is Florida Statute 397. It's the Hal S. Marchman Alcohol and Other Drug Services Act of 1993. The criteria are that the individual is substance impaired, and because of the substance impairment, the individual has lost the power of self-control with respect to substance use, and either of the following: has inflicted or threatened or attempted to inflict or unless admitted is likely to inflict physical harm on themselves, or they're in need of substance abuse services, and by reason of substance abuse impairment, their judgment has been so impaired that the person is incapable of appreciating their need for such services and of making a rational decision in regard thereto. However, mere refusal to receive such services does not constitute evidence of lack of judgment with respect to their need for such services. So when you read through the criteria, it makes sense that people get pretty confused by this. There's so many different ways this could be applied to so many different people. And I've often heard folks say that these criteria would probably apply to most of the folks who come here for spring break or for truck week. I've actually heard some folks say that the criteria are so broad that they're surprised that the ACLU hasn't come after this as an infringement on people's rights. So no regulation is perfect. And the way that the Marchman Act is written can be confusing. So what I'd like to do is break down the different ways that a Marchman Act can be initiated. So the first way is by protective custody by law enforcement. Also, a physician, an APRN, or a licensed clinician can initiate a Marchman Act. A family member or a friend can file a petition to the court, and a judge can issue an ex parte. And those are the four main routes by which a Marchman Act can be initiated. Let's start with the Marchman Act that's initiated by law enforcement officers. Basically, the person is placed into protective custody, and under the regulation, they can be transported to the nearest hospital, addictions receiving facility, or detox center. This is where we begin to see problems with how this regulation is written. The primary problem is that hospitals are rarely, if ever, also licensed as detox facilities. So the most that a hospital can do is provide some PRN medication for how the person is doing physiologically right then and there. They can't actually enact a detoxification protocol for the person. For detox centers, an officer could also bring a person there, but the problem is that detox centers are not always licensed as addictions receiving facilities. And if they're not an ARF, they can't hold that person on an involuntary basis. So the individual would have to be willing to sign themselves in on a voluntary basis. Of course, the ARF is where you want the person to end up, at the addictions receiving facility. Now, the Chet Bell Crisis Center out on Red John Drive here in Daytona Beach is a licensed ARF. Or also a Baker Act receiving facility. But the issue now becomes occupancy. There aren't a lot of ARF beds out there. We only have 19 of these beds over at the Chet Bell Crisis Center. So it can be very challenging because what the regulation states is that if an officer brings a person under protective custody to an ARF and the ARF is full, the officer is then supposed to bring the person down the street to the county jail. And I'll take my hat off to Dr. Flowers and his team out there because they maintain two big dormitories, 60 beds apiece, one for men and one for women, where they do detox for the inmates that are there at the Volusia County Branch Jail. We only have 19 beds at the Chet Bell Crisis Center for addictions receiving. And you can imagine those stay very, very full. Two other options for a police officer who puts a person under protective custody for the Marchman Act would be to bring the person home or directly to jail. Now, the person can only be transported home if there's an individual there at the home who's willing to assume responsibility for them. And the person would normally only be brought directly to jail if they begin to become combative or aggressive towards the officer. Because of the issues of occupancy out at the Chet Bell Crisis Center, we rarely receive anybody under a protective custody for the Marchman Act. Another way is to have the Marchman Act initiated by a physician or a clinician or another medical professional. And this now includes APRNs. Basically, the professional completes the petition and they contact law enforcement who comes to pick up the person to bring them to the nearest addictions receiving facility. I should mention that both for the protective custody and for the professional certification, an ARF can hold an individual for up to 3 days for assessment and stabilization. One of the most common ways that we receive individuals at the Chet Bell Crisis Center is via a Marchman Act that's initiated by family or friend. And this is where things can go wrong pretty quickly if the individual that's filing the petition, the petitioner, doesn't understand how the process works or only takes the process halfway. It's essential that that person obtains both petitions. They're called the Marchman Act 1 and 2. Technically, they're the petition for assessment and stabilization and the petition for treatment. And it's essential that when a person goes online to DCF's website to download these, or if they actually go to the clerk of the court's office, that they pick up both of those petitions, both the assessment and stabilization and the treatment petition. I always encourage individuals to fill out both petitions at the same time with as much detail as possible. Now, you want to file that petition in the county where the person resides. And here's the key. The person would file the assessment and stabilization petition first, and they would hold on to the treatment petition because that will be filed at a later date. The judge will review the petition for assessment and stabilization, and the judge has different options as to what they can do. They could read over the petition and decide there's not enough information there and dismiss it, or they could set a date for a hearing at which both the petitioner and the respondent have to go to. And that would be within 10 days. Now, if the petitioner doesn't show up to that hearing, the judge will typically dismiss the petition. If the respondent doesn't show up for that hearing, typically the judge is going to order an ex parte. Now, the judge could also order an ex parte immediately, and that allows the sheriff's department to go and get the respondent and bring them directly to the nearest addictions receiving facility. So whereas the regulation states that individuals under a protective custody cannot go into an addictions receiving facility if the unit is at occupancy, in the case of the Chet Bell Crisis Center, that's 19 people, it treats the ex partes differently. Because the court order is specific to the addictions receiving facility, the person has to be held until they can be admitted into the unit itself. Now, at the Chet Bell Crisis Center, we have what's called emergency services, which is like a secure emergency room, if you will. It's a locked unit, and we can keep people there under an ex parte for the Marchman Act until a bed does open up. So once the person arrives at the addictions receiving facility, they're going to be seen by a nurse for an assessment. Our average time until we can sit down and do the nursing assessment is about 2 to 3 hours. It all depends on how many folks we have in emergency services on that day, but it's about 2 to 3 hours. They're then admitted back to the unit when a bed becomes available, and they're seen by a medical provider. In our case, we have an APRN who does a full history and physical. That APRN will then put the person on a detox protocol, and they're seen as quickly as possible by a master's prepared clinician or a certified addictions professional for what's called the biopsychosocial assessment. It's about a dozen pages long. It's a very in-depth assessment. And the petitioner who got this whole ball rolling will actually be contacted by the clinician to get ancillary information to complete that biopsychosocial assessment. So when the biopsychosocial assessment's been completed, it's then filed with the court. It's at this time that the petitioner is then able to file the petition for treatment. Now, the petition for assessment and stabilization will only allow us to hold an individual for up to 5 days. The petition for treatment is for a residential program. That could be anywhere from 30, 60 to 90 days, maybe even 6 months, and in some cases, even up to a year. Now, one of the good things about this is that if the petitioner does file for treatment and the court orders it, the receiving facility can actually hold that person at the unit until the next court date. And that can be a lifesaver because people are often, they go back out and they begin to use again right away because they've only been detoxed. There really hasn't been any treatment done. So folks are very susceptible to relapse upon leaving a detox facility. And the fact that if that part 2, that petition for treatment is filed, allows us to hold the person until the court date, that gives us more time to work with the individual. And that can be crucial. So if the petitioner does file that part 2 for treatment, the judge will set a court date and review all the information, including the biopsychosocial assessment that we provided. And they can order the individual to outpatient treatment or to residential treatment. Now, there's always the chance they might not order them to anything, but that's pretty rare. If a family member or a friend has gone this far to take the route of the Marchman Act, then usually the person does need at least the outpatient level of treatment. Now, sometimes what happens is the judge will order the individual to go to a program for long-term, a residential program, and there's not a bed available immediately. So in these cases, the judge will order the person to attend outpatient treatment until a bed does become available. And then during that time, they will need to submit to drug tests and to attend counseling. And if they don't, an order to show cause can be issued and the person can be picked up and brought to jail. Going to jail, it's not ideal, but it does keep the person safe. So if the person is remanded to outpatient or to residential and they're not compliant, that program, either the outpatient program or the residential program, can file a petition for an order to show cause. The judge will then issue the order to show cause, and the sheriff's department will find that person, pick them up, and bring them to jail. And the possibility of going to jail may provide motivation to stay in treatment as well. So it can be a very long and confusing process for people, but it's a very powerful process. Just filing the part 1, just the petition for assessment and stabilization, rarely has the desired effect of getting the person onto the road for recovery. People who have this illness need the time to heal, to look at the reasons behind the use, possible trauma that's driving the use. Without that time, healing can't start. And that's why I always encourage individuals and family members that if they're going to file these petitions, they take the totality of it and use the totality of the regulation, both the parts 1 and 2, to really affect change. I know it's a lot of information, and I talked pretty quick. Does anybody have any questions?
Thank you so much, Tori. You're welcome to put your questions into the chat box, or if you'd like to raise your hand, move your cursor toward the bottom of your screen and you should see an option to raise hand, and we can recognize and unmute you and you can ask your question verbally. Tori, what region does your ARF serve?
That's a great question. So SMA Healthcare, we are in Volusia, Flagler, Putnam, St. Johns, Marion, and Citrus County. However, DCF has what's called a no wrong door policy. Now, when I first came on board with the company about 9 years ago, we only took individuals that were from counties that were within our catchment area. But since DCF has come up with a no wrong door policy, which basically means you get help wherever you can find help because of a scarcity of beds, we take folks under the Marchman Act from outside of our catchment area as well. Now, it can make it more difficult on the petitioner if the individual goes to a facility that's outside of the county. And that's because that part 2 for treatment, it has to be served to the individual in the county in which they reside. So let's say the petitioner lives in Flagler County or even farther away, let's just say Lake County for argument's sake. And they filed that part 1 in Lake County where the person resides. The person was served. The only bed available was over at the Chet Bell Crisis Center, or maybe the person has an open case of this already. So they come over to the Chet Bell Crisis Center. Now the petitioner files part 2 after the biopsychosocial is done, but it has to be filed in Volusia County. So that can make things tricky because of transportation. It can really extend the time that it takes to get this done. But to make a long story short, to answer your question in a succinct way, we take folks from any county now. because of
Okay, thank you.
wrong door policy. Sure.
Thank you. Kelsey Burgess has a question in the chat. What evidence or how much evidence needs to be proved to get one approved by the courts?
That's a great question. It's all about the amount of information and the detail that the petitioner can put into that petition. I encourage folks to, if they've got photos of the person's paraphernalia, to include that. Of course, if the person is overdosed, that's going to really paint a picture for the court immediately that this person is, going to end up dead. I've even had petitioners who have put, photos of the individual passed out into the petition. And whatever a petitioner can do to demonstrate to the court how grave the situation is, I tell petitioners to do it. Don't spare any details. There's nothing to be ashamed about. This is an illness. You have to be able to show the court the depth of that illness. So you've got evidence, you use it, you include it in that petition. Absolutely.
Thank you. And how many ARFs are there in Florida? Do you know?
I don't have an entire count. You can go online to DCF's website. I have a slide at the end of this presentation that will show you how to reach DCF's frequently asked questions page about the Marchman Act. DCF maintains really, really good frequently asked questions pages for both the Baker Act and the Marchman Act. And on that page, there's actually a list of all the DCF licensed detox centers and addictions receiving facilities. There are a lot of them. There are nowhere near as many juvenile addictions receiving facilities, JARFs. Those are definitely harder to come by.
Thank you. I don't see any hands raised, and I don't see any questions right now in the chat. Kelsey said, thank you for your response to her question. If you'd like to move on with your slides, I will invite everyone to continue to add questions to the chat or raise your hand.
Great, thank you, Lynn. Oops, a little bit too far there. Okay, so 2 additional resources, guys. You can easily Google DCF Marchman Act FAQ. You can also Google DCF Baker Act FAQ. That will take you right to those pages. I'll show you a link for those pages. Again, DCF maintains an excellent resource online for both the Marchman Act and the Baker Act. They're all searchable PDF forms. So many questions that folks don't know they have until they have them. Lots of really random stuff can go down in these situations. I often talk to families who will say, well, my loved one has both a mental illness and a substance use disorder. And of course, we know that a lot of these go hand in hand, that co-occurring disorders are pretty much the norm. Typically, individuals are using to fight the symptoms of an underlying depression disorder, anxiety disorder, even a psychotic disorder. So which do I do first? Can I do a Baker Act and a Marchman Act? And the answer is yes, you can do both of those. The Chet Bell Crisis Center is one of a few facilities that actually has both the Baker Act receiving and the Marchman Act receiving components. So we do get individuals who are first Baker Acted to our crisis stabilization unit. And then during the course of the stay on the CSU, they're served with the Marchman Act to address the substance use issue. So that is allowable, and sometimes it is appropriate. So lots of really good facts, frequently asked questions on those pages. You can also check out our website at www.smahealthcare.org. And also, please feel free to give me a call. My office number is right on here. It's 386-254-1227. I'm happy to guide folks through the process and answer any questions that they have along the way. Not a problem at all. I'm definitely willing to help out with that. And then finally, I also wanted to share our access line number. For those of you who don't know, this is SMA Healthcare's 1-800 number, 800-539-4228. Our access center is open 24/7, and it's the way to contact our crisis response team. Phenomenal group of individuals that are there 24/7, 365 to help folks through a crisis, to talk to folks through a crisis. They can also do a video chat. And we actually interface with law enforcement as well to provide support to some of the deputies in the VCSO. So that's a very valuable resource for folks. They can call anytime they want. There's absolutely no charge, and they can talk with some really good counselors. And I believe that's it. Did anybody have any additional questions?
I don't see any new questions in the chat or raised hands, but would you let them know what the documents, the handouts we have in the chat box are?
Absolutely. Thank you for reminding me, Lynn. So in the chat box, there are links to these petitions. So there is the part 1 for assessment and stabilization. There's the part 2 for treatment. There is also the professional certificate that could be completed by a physician, an APRN, or a licensed clinician. So those are the most recent versions of those forms, and you guys can print those out and fill them out. Or if you have the fancier version of Adobe, that will allow you to modify Adobe documents. You can actually just type right on them.
Thanks so much, Tori. Really appreciate that. And I believe we also placed your slide deck in there in PDF version. So that's available too.
Yeah, thank you for doing that.
Absolutely. Thank you so much, Tori, for sharing your expertise today. It was really wonderful. And I'd like to ask attendees to please use the link. Tracy, if you could place the link for the session evaluation into the chat box as well. If not, you will certainly receive this after the summit is too. You'll receive information on how to evaluate each of the sessions and the summit overall. So we appreciate that. And let's see here. I think you can go back to your program again to choose the next session that you would like to visit. Just click on the title. The link will be there in the title of the next session. And we hope that you're going to continue to join us for the rest of the day and our conversations scheduled for tomorrow. Thank you, Tracy. The pathforhopesummit.com/summit2021 site is in the chat, and you can visit there to see the program. Again, thank you so much, Tori. We really do appreciate it. And I'm going to, thank you. I'm going to close this meeting now. Thank you all.
Thanks.